Hello, everyone. Thank you for coming to our third webinar from the Web3 legal series. And before we start, as usual, I would like to check whether the connection is good and whether you can hear me well and whether you can see the screen. So please send plus to the chat of this webinar room. It will help me to be sure that all our technical conditions are properly set up. So today, our main topic will be about Web3 products legal structuring. And if you attended our previous webinars where we discussed the general overview of Web3 legal structures, and also where we covered the topic of IP structuring or intellectual property structuring for the Web3 projects, you might find that the next very important component of this Web3 structures is related to the Web3 products. And today we will cover a bit the different types of these Web3 products and also some peculiarities of their legal structuring. And before we start, I would like to explain the agenda of this webinar. So we will split it into two parts. The first part will be more the content part. So I'll explain some concepts, some legal concepts of Web3 products legal structuring. We will also discuss some criteria when it comes to legal structuring of Web3 products when choosing the country for Web3 products registration, and for some other quite important matters. And the second part of the webinar, we will be able to spend for a Q&A session. So please feel free to send all your questions into the webinar chat. It would be great to cover it in the end of after we finish this first content part. And welcome again to our third webinar. Before we start, also just a few words about myself. My name is Nestor. I'm a co-founder of Legal Notes, and I'm also an international legal consultant working with the Web3 and blockchain companies since 2015. Since that time, I conducted more than 100 discovery sessions with the founders and collected some information and knowledge that I'll be happy to share with you today. And also, I'm a contributor to Legal Notes Resource Center, where you can find more information about the concepts that we will discuss today. So you are very welcome to visit our Legal Notes Resource Center on our website, legalnotes.com. Hope it will be interesting and helpful. And speaking about Legal Notes, this is the platform that helps founders to solve their cross-border legal matters. This is especially relevant for the Web3 founders who usually try to find the most suitable countries for their companies for registration of their companies. The Web3 founders also need to understand what might be the legal and tax consequences in these different countries, need to double check the legal status of their tokens, etc. And that's the moment when Legal Notes can provide the most value, as the Legal Notes will act in this process as the dedicated legal manager for such Web3 founders. We call this service virtual legal officer, and basically this virtual legal officer will help to engage the most relevant local legal provider and manage their work, including the checking of price and time estimates, updating the status of the work, and helping the founders to collect all necessary information. So please feel free to visit our website, legalnotes.com, and we'll be happy to talk about it more. Another very important information which is related to the content that we will discuss today, it relates to the disclaimer that this information is not a legal advice, and please take it seriously, as all information that we will discuss today is for informational purposes only, and all concepts and all general overview of some jurisdictions and local regulations should be double checked and proved by with the local qualified providers. And that's also something that you can cover on Legal Notes platform. So please feel free to come on our website, book a chat, and we will be happy to talk. So our main topic today is about Web3 products legal structuring. And before we start, I would like to make this quick introduction into the general idea of the infrastructures. So you can see a few types of vehicle on this slide, including the cars, the trains, the planes, and it's obvious that each of these type of vehicles need its own infrastructure where they can work and where it might be used properly, and where there will be this like bridge or this place where the end users of these vehicles will be able to interact with these vehicles itself. The same situation is with this decentralized vehicles, which are basically the smart contracts. On our first webinar, where we covered the general concept of DApps legal structuring, we spoke about this main difference between the Web3 on-chain and the real-world off-chain parts of the products. And basically, this part of the on-chain part, included the system of smart contracts, where each of the smart contract might cover its own function. For example, some of smart contracts will issue the tokens. Another one will cover these DeFi business models. The third one will launch some GameFi or SocialFi vehicles. And the system of these smart contracts is usually called the on-chain entity or the on-chain vehicle. But at the same time, we know that there are the end users who will need to somehow interact with this on-chain part. And for these purposes, the Web3 founders usually think about the Web3 products, which will be basically some kind of this infrastructure for decentralized on-chain vehicles. And among these Web3 products, we can highlight the crypto exchanges, wallets, and NFT marketplaces. That's basically some kind of infrastructure for the tokens. We can also speak about the liquidity providers and some crypto loans platforms, which are closer to the DeFi models. And speaking about the GameFi and SocialFi, we can highlight this play-to-earn games, multi-earn apps, and probably some blockchain-based social networks where it's possible to also interact with this on-chain decentralized vehicle, especially with the tokens or with some treasuries or with the voting process, etc., etc. So that's the general overview of the place of these Web3 products in the whole decentralized ecosystem. But when it comes to this Web3 products legal structuring, the Web3 founders usually face some legal related questions, including the question about the country where such Web3 products might be structured and where the company for such Web3 products might be registered. This also includes the questions about the authorizations and licenses, as this activities usually involve virtual assets. It probably might include some financial business models. So all these matters should be taken into account when it comes to legal analysis and legal structuring of such Web3 products. And also the AML and privacy compliance, which is also very, very important part of Web3 products legal structuring, and we will cover it in more details a bit later. So all this information helps us to structure our today's agenda. And I would like to start our main part of the webinar with the main difference between regulated and unregulated Web3 products. We will discuss the main criteria that helps to make this distinguish between these two models. And we will also clarify the criteria which will trigger some specific regulations in this area. After that, we will speak about the exchanges and wallets, which are very important when it comes to token listing or to the liquidity providers. We will continue with the NFT marketplaces, which is one of quite a hot topic during last year. And there are also some very important moments to discuss in terms of NFT marketplaces legal structuring. We will also cover the DeFi, GameFi, and SocialFi projects and their and some legal specifics and legal matters around these concepts. And in the end of the webinar, we will discuss the role of the product distribution company, which in some cases should be registered to help the founders to better deliver their service, their Web3 products, and to also properly structure these innovative business models. So, as I mentioned, the first question will be about the main differences between the regulated and unregulated Web3 products. And also we will discuss the criteria which triggers some specific regulations for each kind of this Web3 products. Basically, I would like to split all these Web3 products into three parts or into three categories. The first one will include wallets, exchanges, and NFT marketplaces. The second one will include liquidity providers and crypto loans platforms. And the third one will include GameFi, SocialFi, and some other platforms which are built on top of the blockchain technology or on top of the on-chain decentralized vehicles. And speaking about this first part or this first category of the Web3 products, which includes the wallets, exchanges, and NFT marketplaces, the main criteria that should be taken into account by the Web3 founders when it comes to legal structuring of such types of products is whether the founders of such Web3 product can touch the end users' funds. So whether they can control them, whether they can withdraw them or manage somehow in a different way. So that will be one of the most important criteria, which will trigger some specific regulations, which we will cover a bit later. Secondly, when we speak about some DeFi projects which need this connection with the liquidity providers or some crypto loan platforms, etc., the main criteria which should be discussed here is who is the actual owner of these liquidity pools and whether these DeFi projects are launched with the usage of their own liquidity pools or they are just some kind of intermediary or the platform where from one side there are the end users who would like to stake their tokens and from other side there are some market participants which need to rent this liquidity. And the third criteria, which is related to this GameFi and SocialFi projects, is related to the personal data, to the personal data of the users. Because in case these apps collect the personal data of the users, there will be some part of privacy or data protection related compliance that should be also taken into account. And we will also speak a bit more about different business models of this GameFi and SocialFi products. So hope it will help to clarify the whole list of criteria that are super important for Web3 products legal structuring. So that's the general overview of the main criteria of each category of of Web3 products, which usually triggers some specific regulations. And on the next slides, I would like to explain you these specific regulations, their different types, and also we will discuss in more details how this criteria and these specific business models might affect the legal structures for the Web3 products. And let's start from the crypto exchanges and wallets. First of all, we can split all crypto exchanges and wallets into two different types, the non-custodial one and the custodial one. Speaking about the non-custodial one, this is the type of the exchanges and wallets. And if we speak about the exchanges, it will probably include the decentralized exchanges. For this type of exchanges and wallets, it will mean that all all virtual assets that might be stored using these services are fully under the control of the end users. So the end users hold these private keys, which allow them to independently open their wallets or exchanges, or send the transactions to the exchanges, or even create the orders without any centralized intermediaries. At the same time, there are also the custodial crypto exchanges and wallets, where the founders or the owners or the moderators of these custodial wallets and crypto exchanges might access the client's funds. So it means that the administrator or the moderator of this platform is an owner of the private keys to the main asset storage of these platforms. And speaking about the legal consequences of each of these structures, we can say that this centralized management and centralized ownership of the third user's funds will result some kind of triggering of some specific regulations, which we will discuss on the next slides. Speaking about such regulations, we can split them into three different types. The first one is the authorization. The second one is includes crypto licenses, and the third one includes the fintech licenses. So let's speak a bit more about each of these types of regulations. Speaking about the authorizations, the main question here is related to the criteria or to some peculiarities of these authorizations when it comes to legal structuring. And basically, these authorizations usually include the AML authorizations, which are usually provided by financial intelligence units or financial investigation authorities, which are, in the most of the cases, the responsible governmental bodies for all anti-money laundering related matters. And in the end, the company which plans to obtain this authorization will be required to implement the KYC and AML procedures. The second category of this crypto-related regulations includes the crypto licenses. And this is more sophisticated type of crypto-related regulations, especially for the exchanges and wallets. These crypto licenses include the specific crypto-related licenses, and we will speak more about some examples on the next slide. And these licenses are usually provided by the financial regulatory authorities, which usually have this the broader powers in relation to the financial markets. And this, considering that these licenses are more sophisticated than authorizations, there are much more requirements for the companies which plan to obtain these licenses. And among such requirements, we can highlight the required authorized capital, the annual audits, and the proper AML and KYC compliance. And speaking about the fintech licenses, that's basically the part of the regulations that usually helps the wallets and exchanges to create this bridge between the fiat and crypto and add the possibility for their users to make these conversions from crypto to fiat and vice versa on their platforms. And among such fintech licenses, we can highlight the EMI licenses, which are the electronic money institutions, and also some payment processing or payment services licenses, which mostly include these different fintech licenses in different countries. And the requirements are quite similar to the crypto licenses. They usually include also this annual audits, ML and KYC compliance, and the required authorized capital. So here you can find some examples of each of these authorizations and licenses. And the general idea when it comes to the exchange and wallets legal structuring is, again, to understand whether it will be the custodial or the non-custodial exchange or wallet. And the next step will be to define what will be the business model or which kind of services these exchanges and wallets will provide to the end users. And in case this is the crypto wallet and it just provides the storage of the virtual assets of the users, probably some types of authorizations which might be obtained in Estonia or in Canada or in Ireland might be sufficient for this case. But at the same time, if it's more sophisticated business model and if it's a wallet with the crypto payment processing or exchange with some crypto acquiring services, there probably might be important to obtain a proper crypto license. And among these crypto licenses, we can highlight the Gibraltar DLT license, the United Arab Emirates Financial Institution Permission, and also the digital token payment license in Singapore. That's just a few examples of these crypto licenses which might be specifically suitable for the exchanges and wallets. And in the end, in case the wallet or exchange plan to integrate this possibility to make a conversion from the crypto to fiat and vice versa, there probably might be the necessity to additionally obtain some traditional fintech license, the EMI license or the money transmitter license. And you can also find more on the screen some quite popular licenses in the UK or in the US. But the most of the countries today have their own fintech regulations and fintech licenses. So it's always better to get a proper local consultation when it comes to the structuring of the crypto exchanges and wallets. So to sum up this part of our webinar, first of all, it's very important to define the business model and the type of the crypto exchange and wallet, which might be the custodial or non-custodial. And secondly, it's very important to define the whole list of crypto and financial related services that will be provided by this exchange or wallet to understand which type of regulations might be applicable specifically for such type of the Web3 product. That's all about the crypto exchanges and wallets. And let's move to our next question, which is related to NFT marketplaces. And basically, we can also divide them into the non-custodial, which offers the users the possibility to own and control the end users' funds, I mean the NFT, by themselves. So the end users might hold this private keys, and they are fully able to sell or sign the transaction with their NFT at any time that they want. At the same time, the custodial marketplaces are the marketplaces where the administrators or the owners of these marketplaces control these NFTs of the end users, which means that they hold these private keys and they can make the transactions by themselves, or they can froze the transactions or make some other actions with the assets of the third parties. And there is also the third type of the NFT marketplaces, which includes the auction models, and that's also something that might require some additional regulations, and we will discuss it a bit more now. So basically, if it comes to the custodial NFT marketplace or the NFT marketplace which involves this auction model, that's the types of NFT marketplaces that might require some additional regulations. And when we speak about the custodial NFT marketplaces, depending on the countries where these marketplaces might be registered, there might be the necessity to obtain the authorization or the crypto license to act as this custodial service provider for the end user. At the same time, if there is some business model related to the auctions, this is also the type of activities which require the licenses in probably the most of the countries. It will also be very important to double check within the local legal advisors whether in the specific country such auction model should be licensed, and whether, and as a result, whether the NFT marketplace should obtain the specific auction license. But in general, the NFT marketplaces differs from the wallets, crypto wallets and exchanges. As when we speak about the crypto wallets and exchanges, we can speak about the virtual assets, which might be traded, might be sold or purchased, and at the same time, which might be used for different payment purposes and are interchangeable. The main difference of the NFT marketplaces is that the NFTs are the non-fungible tokens, which means that they are not interchangeable and that they are quite unique. That's why in some of the countries, the NFT marketplaces are recognized as some kind of e-commerce platforms which sell the digital goods or some other digital commodities. So that's the some general idea of the legal status of NFT marketplaces. But as we discussed previously, it's very important again to clearly define the business model of NFT marketplace, whether this NFT marketplace is custodial or not, and whether there might be some auction models or some other types of regulated models there. At the same time, when it comes to choosing the country for NFT marketplace registration, it's also very important to define whether which kind of company revenue this business model might include, because some of NFT marketplaces provide just a platform where the creators might generate or mint these NFT tokens and then sell it, and the main revenue from these activities is the commission from the transactions. At the same time, some of the NFT marketplaces also allow the users to create these royalty-based models where the users are able to rent the NFTs or provide these NFTs for some third parties for creation of some new intellectual property, etc., etc. And in this case, if there is some royalty-related type of revenue, it might be relevant for the company, for this NFT marketplace, to think about some IP-friendly countries, which might provide some specific taxation regimes for the IP-related income. And among such regimes, we can highlight the IP boxes that are probably which the most of the countries might have, and which might provide quite a good advantages and benefits for the marketplace, NFT marketplaces which will be registered there. At the same time, the location of the creators is also super important, as the creators will expect some profits from their NFT minting or their NFT sale. And there might be some matters of tax residency of these creators, and what will be tax consequences for them, and at the same time for the NFT marketplace, if there will be, if such type of revenue distribution structure will be implemented there. And it's also very important to define the type of NFT, because the classic NFT is usually some kind of newly created digital commodity or digital good. But at the same time, there are different models which involve the fractionalization of NFTs, or which use NFTs as some method of tokenization of some interchangeable assets like lands or properties, etc. In these cases, it's super important to obtain a proper token legal opinion, which will confirm the actual legal status of this NFT, and which will help the NFT marketplace founders to avoid the regulatory risks which might be related to some securities or financial instruments, etc. So, and just a brief overview of some examples where some of the quite popular NFT marketplaces are registered. We can highlight the US, the UK, Hong Kong, Cayman Islands, and you can see that some of marketplaces which might be more related to art are registered in the US and the UK. At the same time, the NFT marketplaces which are more connected to the GameFi industry are registered in Hong Kong and Cayman. And again, that's the main criteria here is this first business model, which is super important, whether the auction models are involved, and whether this NFT marketplaces are custodial or not. So that's the criteria which are highly recommended to be taken into account when considering the countries for NFT marketplace registration. That's all for the NFT marketplaces as a separate type of Web3 products. And let's move briefly to the DeFi, GameFi, and SocialFi projects. The main criteria and the main idea here is also to define whether there are some centralized parts of this of the business models of the services. And previously we mentioned that in case the liquidity pool of this specific DeFi projects is owned in a centralized way by some specific persons with the private keys, which allow them to use and spend this liquidity pool as they want. This might result this criteria of centralization of their business models, and it might have some legal consequences there. Because in case there is some centralization of the third parties funds management, it will definitely be recognized in the most of the countries as the financial services, or probably as the asset management, where this liquidity pools will be privately owned. And it will be super important to make a clear analysis in these countries and in these markets, which kind of financial licenses such providers should obtain for launching such DeFi, or let's call it semi-DeFi business model. At the same time, the most of the DeFi projects try to follow this concept of decentralized, ownerless, and permissionless on-chain vehicle, which is owned by DAO, and where there is no centralized owner of liquidity pools, and all the assets are controlled and managed fully on chain according to the rules of the smart contracts, which are again in the most of the cases open source, and which are also and which also don't require the centralized moderators and administrators, and might work in a fully autonomous way. The similar approach might be applied to the GameFi and SocialFi products, and in case there is no centralized place where all the personal data of the users are stored, and at the same time, in case there is no this game of chance models, or sometimes it also might be called the gambling or betting models, in the end, this GameFi or SocialFi project might also require this specific regulations. If we speak about the personal data collection, these regulations will include the data protection compliance, and if this project is registered, for example, in the EU, there might be some GDPR compliance, for example, and there should be a properly prepared privacy policies, data protection policies, cookie policies, etc. And at the same time, if there is some game of chance models, some specific gambling or betting licenses might be also required. So the main criteria here is to clearly define the business model of such GameFi and SocialFi projects, and the list of services that these projects would like to offer to their end users. Speaking about the decentralized type of these GameFi and SocialFi projects, the approach is the same as for the DeFi. In case all this like virtual asset related matters in the business models of GameFi and SocialFi are controlled by decentralized smart contracts, these models will be probably recognized as this ownerless decentralized entities, which are owned by the DAO and which are controlled by these autonomous on-chain vehicles. And in the end of our webinar, just a few words about the product distribution company, as this company is super important when it comes to the Web3 product legal structuring. Among the main areas of responsibilities of this company, we can highlight the two ones. The first one is the publishment of the terms and policies. And in case this is a regulated crypto exchange or wallet, or the regulated NFT marketplace, there probably will be some terms and conditions. There might be required to publish this KYC and AML policies and verify all the users. In case it's an NFT marketplace, there also might be some consumers' rights protections policy, and there should be also the compliance with the specific regulations as well. So that's all the matters that are usually covered by these public documents, which are published on the interfaces of these Web3 products in the websites, mobile apps, and some other types of interfaces. At the same time, this product distribution company might be also responsible for obtaining the specific authorizations and licenses. And among such authorizations and licenses, we have already discussed the specific AML authorizations for the wallets and exchanges, the specific crypto licenses and fintech licenses, again, for the wallets and exchanges, specific auction licenses, or again, the custodial service providers licenses for the NFT marketplaces, probably some financial licenses for the DeFi, which are owned by some centralized beneficiaries and shareholders, for example, and where these liquidity pools are also owned in a centralized way. And again, some game of chance related licenses that might be relevant for the play to earn games or GameFi projects, which plan to launch the business models which such specific play to game of chance models. So that's the general overview of the main areas of responsibility for the product distribution company and its role in the whole Web3 legal structure. That's all for today. Thank you very much for your attention. Hope it was helpful, and hope you found some useful information here, especially including with some part of the overview of the countries where some of the Web3 products are structured, and also with some types of regulations that should be checked before launching some specific Web3 product. I would like to invite you to our next webinars, which will come in the next week, this week and next week. So we will speak more about the tokenomics, legal structuring. We will discuss the token cap table, token distribution plans, and the legal consequences of token issuance and where to register the token distribution company. We will also speak more about the Web3 fundraising as it's different from the Web2 fundraising, where there are some best practices, well-established documents, etc. And the third webinar and the last one will be about the DAO legal structuring. So I hope to see you on these webinars, and hope they will also be useful for you. And as I mentioned at the start of this webinar, we will have a Q&A session in the end of this content part. So again, you are very welcome to our next webinar about tokenomics and token issuance, which will be on this Thursday. And at the same time, if you want to discuss some Web3 products related questions on the private chat, I would like to invite you to book a call using this QR code or using our website legalnotes.com, and we will be happy to have the chat and to discuss what might be the options for your Web3 product legal structuring. So thank you very much for sending your questions into the chat. I'm very happy to see it. And let me start from the first question, which is as follows. Can you provide an example or use case in which NFT is managed by the DAO in order to provide a specific service and or benefit? So basically, it's very important to, again, distinguish this on-chain and off-chain parts of each Web3 product. If we speak about the NFT marketplaces, the on-chain part of this NFT marketplace will probably include the smart contracts where these NFTs might be minted, and where the users will be able to create their own accounts or wallets and store their NFTs, send it, etc., etc. And this smart contract is usually once deployed, and since that time it works as the autonomous decentralized vehicle. But at the same time, there might be the necessity to, for example, change the rules of the smart contract or change the rules of the token minting, or define some commissions that the smart contract will cut from each NFT sale, or probably some royalty related revenue distribution, etc. And if we speak about this decentralized concept, the smart contract is usually owned by the DAO, which is structured as the final stage of Web3 product development. And these DAO members might vote on how they would like to see this on-chain smart contract of NFT marketplace. So that's the potential use case of how the NFT marketplace might be owned and managed by DAO, and why this and how this concept of ownerless and permissionless on-chain vehicles might be followed in connection with this NFT marketplace model. I hope I answered any question. However, if you would like to send any clarifications, please feel free to do this in the chat, or just book the session using the QR code on the screen. We will be happy to talk more about this. We have another question from Nick. Hi, we are planning to launch a play-to-earn game, but according to to your webinar, there has to be a license in place. What are the countries usually the best option for obtaining such license? And is that possible to obtain only the one license in one country to cover all jurisdictions? Thank you very much for this question. First of all, it will be very important to understand which kind of license it will be required to obtain for your play-to-earn game. Because there might be plenty of licenses. It might be the crypto custodial license for storing and processing of third parties' virtual assets. It might be the licenses which are related to the game of chance models like gambling or bettings. And there might be some other kind of licenses. So first of all, it will be very important to define the business model of your play-to-earn game. And the next step will be to understand which kind of license might be the most relevant to provide such kind of service in a compliant way. And secondly, speaking about this cross-jurisdictional moment of licensing. First of all, it will be very important to clarify where your main users will be located and what will be your primary market. In case your primary market will be the EU, we can speak about some EU licenses, about the licenses of some EU countries, which might allow the project to offer such services to the whole EU market. The same situation might be in the US, where there are these two-level licenses, the federal one and the state one. And in some of the cases, just the federal license might be enough. In another one, like the federal license as well as the local state license might be required. So this is very case-by-case basis requirements. And the general rule or the general idea here is that it's always important to have the license per market. And this markets to have just one license for the whole market. It's very important to clarify whether there is this unified or united legislation on this specific market. And one of the example might be this EU countries, where there is the general, quite a similar regulatory framework on the EU level, but at the same time there might be some regulatory peculiarities on the country level. So that should be definitely taken into account. So I'm ready for another one question. So please feel free to send it to the chat. At the same time, I'd like to remind you that we are waiting you for our next webinars. So please feel free to register on it, add to your calendar. And we hope that you will also be able to find more useful information about the Web3 legal structure in there. So it seems that we are there are no other questions regarding the Web3 products. So I would like to thank you again for attending this webinar. I hope it was useful, and hope you found some useful insights from this webinar. And looking forward to meeting with you on our next webinars. Have a nice evening and goodbye.